Hi, everybody. It's Mike Kennedy, Vermont Bar Council. Welcome to another week. We're going to start Monday off with the answers to Friday's 241st 5 for Friday legal ethics quiz. I like doing the answers by video to get into a little bit more explanation and discussion of each question and answer than I can get into on the blog. First, the introduction to Friday's quiz caused a little bit of controversy. There was no controversy in the fact that, yes, Mike, you are an idiot for not having known until you played the Sporkle game recently that 1 isn't a prime number. I will go to my grave insisting that in elementary school, I was taught that a prime number is any number that is divisible by 1 and itself. And I would argue that 1 is divisible by 1 and itself. That's not the case. I'm wrong. I concede. Where the controversy arose is there's a debate over whether 2 is a prime number. I thought it was. Of course, I'm not reliable on this topic, as we know, because I didn't know that 1 wasn't a prime number. I have an official mathematician of my blog, JD, my buddy. He's going to come on soon whenever I get around to having guests or starting my podcast. And he's going to weigh in with the official opinion of Ethical Grounds as to whether 2 is a prime number. Hint, the official opinion is going to be that it isn't. I understand, however, there is some debate on the question. So we will do what lawyers do, and we will debate it by presenting evidence and letting people draw their own conclusions. JD did not know until Saturday, so 2 days ago, that he's the official mathematician of my blog. So we haven't had time yet to set up either the interview or the podcast or the video, however we're going to do it. Okay, so let's get to the questions and answers. Stay tuned for the what I'm sure will be a high quality debate as to whether 2 is a prime number, probably the debate of the year. If we get it in before December 31st, I'm sure to win all sorts of accolades and such as I pass time until I can get the screen to go into presentation mode. Okay, here's question 1 from Friday. I often refer to the 7 C's of legal ethics. So those are the 7 words, single word, that begin with letter C that I use to urge people to think of the rules, not so much as trying to memorize the rules, but thinking of concepts. Easier to do than memorizing the rules. Professor Alberto Bernabe, a regular member of the Honor Roll, University of Illinois, Chicago, John Marshall School of Law professor, uses a similar construct. He suggests that students in his class remember the bad grades. He uses the C's, a D, and an F. His C's are the same as mine. The C's are competence, communication, conflicts, confidentiality, and candor. His F is for fiduciary. What does the D stand for? The answer is diligence, rule 1.3. A couple things about diligence. Remember, you owe your clients a duty to act with reasonable diligence and promptness. It's comment 3 to rule 1.3 starts with something like, perhaps no professional shortcoming is more widely resented than procrastination. So people expect you to do what you've been paid to do, or tell them that you can't do it so they can find somebody who will. Also, when it comes to diligence, comment 5, I think it is, for you smalls and solos, suggests that an aspect of the duty of diligence is having a succession plan in place. So that if something happens to you, there is someone who can notify your clients and make sure that their matters are attended to, either get them to a new lawyer or get them the help that they need until you're able to come back from whatever made you unavailable. Okay, question 2, here's the scenario. Prospective client contacted lawyer seeking representation in a matter in which prospective client's interests are materially adverse to the interest of one of lawyer's former clients. Whew. Good thing I ran yesterday. The new matter is substantially related to the matter in which lawyer represented former client. However, lawyer does not remember anything about the representation of former client and no longer has access to the file. So which is most accurate? This is the common scenario where new client comes in, hey, can you represent me? You find out the other side is a former client. The 2 matters are substantially related. You're wondering what you can do because you recognize it's a former client, but you don't remember anything about the case and you no longer have access to the file. Here are your choices. Of these four, which is the most accurate? A, because the matters are substantially related to each other, lawyer is presumed to have received confidential information from former client. B, because the matters are substantially related to each other, former client will not be required to disclose confidences in order to protect them. C, A and B. Or D, whether lawyer can represent prospective client necessarily turns on how long ago the representation of former client ended. Answers. I like to throw out each week a question that relates to a blog post I'd done earlier in the week, give regular readers a bit of an advantage. And that's what I did this week. So the answer is A and B. I blogged on this on Thursday of last week. I included a video on don't switch sides. And even if you have switched sides, remember, if the two cases are substantially related to each other, we're going to presume that you received from your former client confidential information. And even if you don't remember it, the rule applies, creates a conflict because we are not going to make that former client disclose confidential information in order to protect it. So it's A and B. D, I get every now and then in inquiries where people will say something like, well, Mike, but it was more than 7 years ago, or it was more than, X number of years ago. That's not in the rule. We don't have a bright line like that. Some language in one of the comments suggests that if something is so old, we may not consider it to be substantially related to the new matter anymore, but there's no hard and fast test. Okay, next question. Lawyer called me with an inquiry. I listened and then I replied. I wouldn't call without permission. I understand your point about the matter not yet being in litigation, but the rule is not limited to matters that are in litigation. It applies to any matter. What's the topic of the rule I was referencing? The answer here is, this is Rule 4.2, communicating with a represented person. Remember, the rule applies to matters, not just to something that's in litigation. Also remember, it applies to represented persons, broader than just parties. So it's not parties and cases, it's persons and matters. Question 4. What type of conflict is less likely to be imputed to other lawyers in the same firm as the conflicted lawyer? Is it A, a conflict between a former client and a current client? B, conflict between current clients? C, a conflict arising from a personal interest of the disqualified lawyer? Or D, this is a trick question. In Vermont, all conflicts are imputed to others in the same firm. The answer here is, that's C. It's in Rule 1.10a. We will impute A, conflict between former and current clients, to all lawyers in the firm. We will impute B, conflicts between current clients, to all lawyers in the firm. We don't always impute A. And here's the language. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rules 1.7, which is paragraph B, or choice B, or 1.9, which is choice A, unless the prohibition is based on a personal interest of the disqualified lawyer and does not present a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. I can't say materially. I don't know why. I just can't say it. Anyhow, so those personal interest conflicts, if they're not going to create that risk, all the risks associated with conflicts and appearances and confidences, for the other lawyers in the firm, we're not going to impute them. I like to use an example there where you get a potential case where you find out the other side is your kid's little league coach or your kid's teacher, and it just makes you feel a little awkward. Might be a conflict for me to be involved here. We're not going to necessarily impute that to the rest of the lawyers in the firm. And then finally, the bonus question, Rule 1.D. So the bonus question, as y'all know, usually, I don't know why I said y'all right there either. I think it was because for you football fans, I was watching Brian Kelly with his new Southern accent now that he's no longer at Notre Dame. Anyway, usually pop culture. Not everybody loves the pop culture. So sometimes I try to make it real, related to the rules. Not everybody loves that. They like the pop culture break. A little bit of both this week. Rule 1.d prohibits a lawyer from assisting or advising a client to commit a crime. The rule draws no distinction between state and federal crimes or between crimes that the government enforces more or less vigorously than other crimes. As such, the rule used to cause concern for Vermont lawyers representing clients involved in a particular industry. So much concern that several years ago, 2016, we amended the rule. As amended, a new comment clarifies that a lawyer may assist and advise a client on the scope, validity, and meaning of Vermont law that governs a particular product, as long as the lawyer also advises the client as to the potential consequences of the conduct under federal law and policy. Here are your challenges for the week. Question: what's the product of the industry that we're talking about that we had to amend the rule? Bonus: name the celebrity whose famous holiday song uses the product in a rhyme with the holiday. Double bonus: name the other product that the same celebrity uses to rhyme with the first product and the holiday in one of the versions of the song. The second product isn't associated with Rule 1.d or assisting or advising a client to violate the law, but maybe it was back during Prohibition. So the product, cannabis, marijuana, you can now advise your Vermont clients who are involved in the legal cannabis industry on whether their activities comply with Vermont's regulatory scheme on cannabis, as long as you also advise them that, hey, we're not sure what the potential consequences are under federal law. By doing that, even though cannabis remains a Schedule I drug under federal law, you will not be deemed to have assisted or advised a client to violate federal law, at least for purposes of a licensing case. That was Adam Sandler in the Hanukkah song. Same verse also arises. One version of the song includes lyrics where marijuana, Hanukkah, and gin and tonica are all used. So that's the quiz this week. If you got any questions or want more of an explanation on any of the answers, feel free to get in touch. Otherwise, enjoy the Monday and have a great week, and look forward to talking to you again with the official mathematician of Ethical Grounds, JD, when he comes on to talk about why 2 is a prime number. Take care.